All right, so we're going to start the presentation in just a few minutes. We're going to let our attendees filter in. So I see that we've got about 10 right now. I think we're expecting around 50, 60 thereabouts. So I'm just going to give everyone a minute or two to come on in. So hello, everyone. Welcome to everyone who's joined us so far. Thank you for joining us this evening and giving us your time. We hope that we're very helpful and able to answer your questions. So we've got about 48 people as attendees right now. I think the numbers are going to level out in a second, so we'll probably get started in just about a minute. Okay, so it looks like everybody who was waiting in the waiting room has been admitted, so I think we can get started now. So good evening, everyone. We're lawyers at KPA Lawyers. We're part of the Wills and Estates team here. We're happy to be able to provide you with a free webinar this evening on wills and estates law, just the basics. So if we can start the slides, we'll start the slides in a second, but I'll just introduce all the panelists for the evening quickly first. So my name's Yvonne Iwasaku. I'm a civil and human rights and estates lawyer at KPA Lawyers, who's hosting the evening. And then I'm joined by my three colleagues here. So my colleague Adil Habib, who's also a civil and estates lawyer at KPA. My colleague Jason Senyukov.
Hi, how are you, everyone?
So he's also a civil employment and estates lawyer at KPA, and we're joined this evening as well by Barbara Kay, who is our real estate lawyer and one of our family lawyers here at KPA.
Good evening.
Okay, so between the four of us, we hope we'll give you a bit of an introduction to wills and estates law and answer some of your pressing questions that you might have. So I think we can go ahead and start with the presentation. Looks like we've leveled out on our attendance. Okay. So just a couple of housekeeping matters. As the introduction here says, please save your questions for after the presentation. So we've allocated about an hour for the Q&A session. There's a Q&A tab at the bottom of your Zoom screen where we would ask that you would add your questions. That way we can keep track of them and make sure that we get to all of them. If you add the questions in the chat, we may not be able to get to them, so just remember to use the Q&A function, please. And then once we're done the presentation, we'll also open up the floor to anybody who wants to raise their hand. So that's a feature you should be able to see as well as an option. We'll select people as they raise their hands. Our host for our background host for the evening, Ryan, will add you up. Once you've had a chance to raise your hand and you've been selected to give a question or be part of the presentation, your just your voice, I guess not video, we haven't activated that, but your voice will become part of the presentation. As a quick reminder, we are going to be recording and posting this presentation on social media afterwards. So if you use the raise hand function to ask a question, your voice will be part of the recording afterwards. Okay, so welcome to our free wills and estates webinar by KPA Lawyers. Next slide, please, Ryan. And just to confirm, all the attendees right now are all on mute, so we won't be able to hear you until you begin permission to raise your hand and speak. So that was a question there. Okay, so we're going to be presenting in this order. So we'll be starting with Jason, who will be giving an introduction to wills and estates and inheritance without a will, which is known as intestacy law. We'll move on to my section, which is about powers of attorney and guardianships. So this is a kind of estate planning before you pass away to make sure you're taken care of at near end of life. Then Adil will give a summary of both estate administration and estate planning. And lastly, Barbara will talk about some family law and real estate law pieces that intersect with estate law. And then, like we said, we have about an hour for the question and answer session at the end. Next slide, please, Ryan.
All right, everyone.
Okay.
Again, welcome. Like Ivana had said, my name is Jason Senyukov, and I'm a civil employment and estates lawyer here at KPA Lawyers. And as mentioned, I'll be talking to you about what is an estate, what are wills and why you need them, as well as the basics of intestacy inheritance. So Ryan, if you can, next slide, please. And sorry, one more slide. So an estate is the property that a person owns or has a legal interest in. Now, the term is often used to describe the assets and liabilities left by a person after death, essentially meaning it's an individual's net worth at the time of death. And it includes one's home, bank accounts, car, assets like that, stuff like a stamp collection, jewelry, but also mortgage, debts, things like that to hit your net value. An estate is managed and administered by the estate trustee after you die, and an estate is deemed to be closed once all the assets in the estate have been distributed. And sometimes this takes years, but Adil will be talking about this a bit later. Next slide, please. And one more. So what is a will? So your last will and testament covers the distribution of your property after you die. It also allows you to appoint a person who you like to manage your affairs after death, known as the estate trustee. It's also used to deal with any funeral or burial wishes that you may have, as well as the custody of minor children in the event of your death. Additionally, again, it only takes effect upon your death, which is what differentiates it from things like power of attorney documents, which Ivana will be talking about later. A will could be changed as many times as you like, as long as you're not deemed to be incapable of doing so. So you can also have multiple wills for multiple things. For example, you may have a personal will, you may have a will dealing with corporate assets. And a will is subject, like I said, to several formal validity requirements. For one, it does not have to be notarized, registered, or deposited with a court. It does need to be in writing and signed, as well as witnessed by 2 adults who are not named in the will. Other formal requirements include a testator has to be 18 years or older, subject to some exceptions, as well as, like I said, mentally competent, which includes things such as, can the testator understand the purpose and effects of making the will, the extent of the property which they're disposing of, and potential claims from others that may normally expect to benefit under the will. So next slide, please. So why do you need a will? So I've listed a couple of reasons, but for one, you get to appoint the right person to manage your estate. If you don't have a will, you can't really select the estate trustee or executor who will deal with your estate after you die. And this person will be appointed by the court, but multiple people can apply for this position. Next, you can protect your children and dependents this way. First off, if someone is dependent on you, by making sure you get something that you wish for them to get. If you don't have a will, you can't select the beneficiaries of the estate. Provincial legislation will dictate that, and I'll go over that in just a moment. The will helps you appoint guardians for your children and pets, as well as gives you an opportunity to minimize your estate's tax exposure or probate. And Adil will speak further on this as well. Next slide, please. So the basics of intestate inheritance. So like Ivana said, if you're intestate, it means you die without a will. And the Succession Law Reform Act, provincial Ontario legislation, dictates what will happen with your assets if you die without a will. It depends a lot on family makeup, which you'll see. So first we're gonna go over what happens if you have a surviving spouse and surviving children. It's important to note that in the SLRA, or Succession Law Reform Act, a spouse does not apply to common law spouses. Spouse only applies to legally married spouses. So if you have a common law spouse that you're wishing to inherit after you die, it's best to have a will because they will not be accepted through this SLRA. So if you have a spouse but no children, then the spouse will inherit everything as long as it's equal to or less than the preferential share. The preferential share in the SLRA is defined as up to $200,000 worth of assets. So if you pass away, leaving a surviving spouse, and your total assets equal or are less than $200,000, meaning the preferential share, the spouse will get everything. If you have a spouse and you have a surviving child, then the spouse will get the preferential share, and then the spouse and the surviving child will split the rest of the estate, or the residue, which means leftover, half-half. If you have a spouse and more than one surviving child, the spouse will get the preferential share, followed by 1/3 of the residue, and the remaining surviving children will split the rest of the 2/3. Now, it's important to know what counts as a child, surviving child in the SLRA. So I have just some notes there where a half-blood, so if you have children with different spouses, will inherit the same as a full-blood as long as they're your surviving child. Any adopted children count. And then something called un ventre sa mère. Excuse my terrible French accent, but it means that if you have a child that's conceived but not yet born at the time you die, the child is deemed to have been born. So they would count as well. Next slide, please. So what I have here are just some examples drawn out, illustrating what I've just said. So first you have an intestate and a surviving spouse and a surviving child, and the estate is worth $200,000. So as you can see where it says the answer, because the estate is worth $200,000 or less, the surviving spouse will inherit the preferential share, which is the entirety of the estate. Next slide, please. Now in this example, you have the same family makeup, but the estate is worth $300,000. And the reason this makes a huge difference is because after the surviving spouse inherits the preferential share of $200,000, the child and the surviving spouse will then split the residue 50-50. So what you have here is the surviving spouse is going to inherit $250,000, and the child will get $50,000. And as a final example, next slide, please. It's the same makeup, except now we're adding a surviving child. So in this, just like in the last ones, the spouse will inherit the preferential share, so leaving $100,000 in the residue. And then the surviving spouse and the two surviving children will split the residue of $100,000, 33% each. Next slide, please. Now, if you don't have a surviving spouse, but you do have surviving children, the children will inherit equally. And if one of the children has predeceased you, then their descendants will inherit that share. If you have no spouse and no surviving children, then your parents will inherit completely and split it 50-50. If one of the parents has predeceased you, then the surviving parent will inherit completely. If your parents have also predeceased you, then your brothers and sisters will inherit and inherit equally. If your brothers and sisters have predeceased you, then your nieces and nephews will take it. And if all of the above and your nieces and nephews have all predeceased you, then what happens is your property goes to, or your estate goes to your next of kin. And your next of kin is established by nearest of degree to you by a table of consanguinity. And I know that sounds extremely complicated, but next slide, please. All it is the table of consanguinity lists a bunch of your relatives and puts a number between it. And the number beside it is the degree of closeness between that relative and you. So if you look at brother and sister, it has a 2. And if you look at first cousin twice removed, it has a 6. And so that means that the brother and sister will inherit before the first cousin twice removed. And finally, for intestacy, next slide, please. If you have no next of kin remaining, then your property will go to the Ontario government. And this is known as an escheat to the Crown. Next slide, please. So, what are some issues that can occur if you die without a will? So like we talked about, your property will be divided according to the law, and that is not necessarily according to your wishes. There will also be uncertainty into who will become the executor of your estate, because in your will you get to name the executor. Without a will, like I mentioned, people will apply to court or can apply to court, and it's up to the court to appoint who they want. Because of that, there might be a delay in the ability to administer your estate. Also, it will make it harder to obtain a certificate of appointment of a state trustee, which is the legal document needed for banks, the Ministry of Transportation, real estate companies, and things of that nature as far as doling out the pieces of your estate. Next slide, please. So that concludes my presentation, and I'm going to throw it over to Ivana to talk about powers of attorney and guardianships. Ivana?
Ivana, I think you're muted there.
Thanks, Adele. And as I mentioned to one of the other attendees, if my audio remains poor, if it were, just let me know. I can switch to different audio input. So I apologize in advance if there's any more audio issues. Okay, so I'm going to be taking over to explain powers of attorneys and guardianship. So next slide, please, Fred. Okay. So I'm going to switch over my audio very briefly. I apologize. Just 1 moment, please. Okay. So I apologize for that. Okay. So I'll be proceeding with the presentation from this piece now. Okay. Great. So what are powers of attorney? So a power of attorney is a legal document that gives somebody else the right to make decisions on your behalf. So in short, these are documents that you can use to authorize somebody to make decisions for you, whether it's on behalf of you for healthcare decisions, property management decisions, specifically about one property. There's a range of things you can use to delegate decision-making authority. And there's a range of things that people can have authority over. So powers of attorneys are only effective while you're alive. So like I said at the beginning of the presentation, they deal with, so to speak, end-of-life planning rather than post-death planning. Powers are granted to an attorney and they end when the person passes away. Powers of attorney can only be made voluntarily by a person who has something known as capacity, which I'll talk about in another moment, but it's effectively the ability to make their own decisions. They can be revoked or changed at any time by a person with capacity. And there's 2 main types, one's called property and one's for personal care. Next slide, please, Ryan. So I'll start by describing power of attorney for properties. So powers of attorney for property are documents that you use to convey or confer decision-making authority onto somebody else with respect to specifically it's called property, but it means any of your assets. So whether this is bank accounts, whether this is investments, whether this is rental property, it can encompass a lot of different things. There's a lot of different ways that you can structure a power of attorney for property, and I've listed some of the different ways that you can do it here. So for example, I always ask my clients, do you want your power of attorney for property to be restricted or unrestricted? The difference between a restricted power of attorney and an unrestricted power of attorney for property is that under a restricted power of attorney, your attorney only has decision-making authority over specific items or specific facets of your property. So for example, let's say that you're traveling abroad and your house is about to sell. You can create a restricted power of attorney for property that allows that person to make decisions only with respect to the property that's being sold. They don't have any authority over your banks or investments or mortgage, nothing along those lines, only to agree to, for example, an agreement of purchase and sale. These can be really useful tools if you just need somebody to make decisions on your behalf temporarily, and they can also be really useful tools if you just want to give certain authorities to certain persons. There's also continuing powers of attorney for property. This is the common way to draft a power of attorney for property. It covers decision-making authority and confers it to a person even in the event that you become incapable. And so I mentioned that I'd speak about capacity. I am going to talk about that a little bit later, but just to give you an idea, as I said, capacity is the ability to make decisions, and it's an ability to appreciate the consequences of those decisions, both on persons who may be financially dependent on you and with respect to any kind of obligations that you may have towards others. So a continuing power of attorney allows that person to make decisions on your behalf, even if you've become incapable. Versus a non-continuing power of attorney, which expires on a certain date or after a triggering event, such as, for example, if you lose decision-making capabilities. Another example is a limited versus an unlimited power of attorney. So a limited power of attorney can only be used in the event of an incapacity. So this is, so to speak, the opposite of a continuing power of attorney. Next slide, please, Ryan. So this is the second kind of power of attorney that you can draft in Ontario. They're called powers of attorney for personal care. That's the formal name of the document. They cover your personal decisions, such as housing and healthcare. They're sometimes called living wills, which they're mostly referred to in the United States, so in America, as living wills. We don't refer to them as living wills up here, but if you're looking at articles or if you're looking at or have heard about living wills, these are the documents that are considered living wills. They're also called powers of attorney for personal care because they deal with so much more than just healthcare decisions. As an example here, I've listed that they can also allow that person to make decisions on your behalf with respect to housing, for example. So if you go into a long-term care home or a palliative care home, what kind of palliative care home? So it encompasses a lot of, so to speak, personal care decisions. The powers of attorney for personal care that I draft as well typically leaves directions for your care and for your caregivers about your wishes for your health care and treatments if you are incapable of deciding for yourself. The classic example that I use here is, for example, if you are of a certain faith that doesn't want to have blood transfusions, this would be the place where you would direct your decision makers or your caregivers that you do not want to receive blood transfusions. Another classic example is a DNR, or do not resuscitate. This would be the place where you would leave those directions. And leaving those kinds of directions in a power of attorney for personal care makes it so that your decision makers and caregivers must follow those directions. And some examples of items that I discuss with my clients when we draft these documents are advanced directives, which are advanced decision-making directions about things, for example, such as maybe intubation, resuscitation, along those lines, consent to organ donation, and as I said, a DNR. Next slide, please, Ryan. So this is where I speak about capacity. So what happens in the event that somebody has become incapable or has lost capacity if they don't have a power of attorney? That's where this regime called guardianship comes to play. So first, as I said, let's talk about capacity. Capacity is, like I said, the ability to appreciate the consequences of decisions that you make, both on your finances and on any persons to whom you may have a financial obligation or to whom you may have a familial relationship. When you're incapable, you're deemed to not understand the consequences of the decisions that you're making. Incapacity can occur as a result of a number of events. The classic examples are deteriorating mental health, things such as Alzheimer's or dementia, being placed into a medically induced coma, or simply being incapable of speaking or appreciating the ability to, or simply being incapable of vocalizing your decisions. Capacity is assessed in a number of different ways, but primarily it's done one of three ways. So either by your attending physician and family doctor, they can deem you to be incapable of making decisions with respect to your own health care. It can be done by a capacity assessor, which is a licensed profession in the province of Ontario. Or it can be done by a solicitor, someone who's trained in conducting capacity assessments. So for example, any one of us can perform a very basic capacity assessment. Now, as a side note, before I get into guardianships, it's important to note that in order to make any kinds of decisions, whether it's about your finances, about your personal care, or a decision to make or create any kind of estate document, including a power of attorney, the person must be capable of doing so. And so one of our obligations when we're drafting estate documents is to assess capacity. So what do you do if someone you love is incapable and they need somebody to make decisions on their behalf? So that person can either have an attorney duly appointed under a power of attorney make their decisions on their behalf, or they can have a guardian appointed to take care of that person who's incapable. A guardian is different than an attorney because a guardian is either someone who has stepped into the role of caregiver or decision maker, or it's somebody who's appointed by, for example, a statutory body such as the public guardian and trustee. Becoming a guardian can be as easy as assuming the responsibilities of being a guardian, or it could be as formal as having an actual court order which designates you the designated guardian. A lot of times we're approached when there's conflicts or concerns between attorneys or about persons who are acting as attorneys or guardians. Here's where the statutory guardianship would become involved. So this requires the involvement of the public guardian and trustee. This means that there would be someone formally appointed to be the caregiver. As I mentioned before, you could also bring there could also be a court action for an appointment of a guardian. And if you're concerned with the actions of a guardian or attorney, you could bring a challenge or a request to the court to have that guardian or attorney removed and replaced by somebody else. And if you're concerned about an attorney acting under a duly executed power of attorney, and you're concerned that the duly executed power of attorney was in fact not duly executed or was done when the person did not have capacity, you can also challenge the powers of attorney. The reason I outline all of these is to show that there's a number of ways that as you approach the end of your life, there are ways that you can account for and plan for all the decisions that need to be made. And if there's some kind of concerns, you can also manage around those. Next slide, please, Ryan. Okay. So the benefits of having powers of attorney in place. So as I outlined, it ensures your financial and personal care affairs are managed by someone you know and trust. It gives you the control over who's going to be making those decisions on your behalf if you can't make those decisions. It keeps things uncomplicated. So that means that people know exactly what it is that you want, exactly who should be in charge. It makes it easier for banks, mortgage institutions, insurance companies, everything down the line to agree that this person is the one that should be making those decisions. It prevents the government from needing to get involved. So for example, if, as I was talking about the Public Guardian and Trustee's Office or the courts, if a validly executed power of attorney conducted by or drafted by a solicitor who is assessed capacity is in place, it's much less likely that there's going to be any kind of complications or concerns. It prevents issues at the banks, mortgage company, as I said, reduces the likelihood of conflict between family members. If the decision has been made already, there's no sense in fighting about it after the fact. And specific powers of attorneys can be useful if you travel frequently or for less mobile or elderly persons. So there's lots of benefits of taking control of the end-of-life planning by creating powers of attorneys. Next slide, please, Ryan. All right, I believe this is Adil's portion of the presentation now. Adil?
All right, thanks, Ivana. I'm going to be dealing with estate planning and administration. Next slide, please, Ryan. I think there's a bit of an echo. Is that better? Sorry, just give me 1 second. How's that? Is that better?
You're good, Adil.
Okay. All right. So what I'm going to be starting with is just an intro into trusts. There's two types: inter-vivos trusts and testamentary trusts, and then some of the pitfalls and complex solutions. Oh, I think I know what it is. Sorry, just bear with me 1 second. Is that better?
Sounds fine to me, Adil.
Okay. I'm just going to continue. That's fine. So yeah, pitfalls and complex solutions, and then trust and planning for blended families. And then finally, I'll get into estate administration, which is commonly known as probate. And that deals with basically what happens when someone passes and what you're supposed to do. Next slide, please, Ryan. So what is a trust? The best way to describe it is that it's a legal mechanism and it's created by a deed or a will. And essentially what a trust does is that it allows a person or a corporation even sometimes to hold property or assets for the benefit of a particular person or even a corporation sometimes as well. And that person is known as the beneficiary. Now, the person or corporation that manages the trust is referred to as the trustee, and they have an obligation to deal with the property for the beneficiaries of the trust. Now, there's many kinds of trusts that you can have, both when you pass and both when you're alive, and I'll be getting into that in the next slide. Next slide, please, Ryan. So this is just an example of how a trust is essentially created. It's a very bare bones basic example. But you've got Bob there. He's the settlor, and he's the person that originally has assets. So Bob may have cash in his accounts. He's got investment stocks. He's got a property, and he's got share certificates in his corporation. And so as the settlor, he has legal title to these items, but he will be putting legal title with respect to any of these items to a trustee. And that can be a person, and sometimes it can be a corporation, as I mentioned before. And the trustee will have the obligation of managing these assets for the benefit of the beneficiaries, and that, that might be Bob's wife or his children, or it might also be a corporation. So that's essentially how a trust is formed and how it's utilized. Next slide, please, Ryan. So there are two types of trusts. There's an inter vivos trust, which is referred to commonly as a living trust. This is where the assets are transferred to the trustee during your lifetime. You've basically separated your legal ownership with respect to that property, but you maintain control through the trust deed because it dictates how the trustee is supposed to deal with your assets. One of the main reasons trusts are created while you're still alive is obviously for tax saving purposes. Properties are transferred to a trustee so that you are able to get some of the tax saving benefits through income splitting, and I'll get through that into the next slides. But of course, I've put stars there because that's a caveat. You have to be careful that you are actually going to receive some of the tax saving benefits. The CRA is constantly changing the requirements for valid trusts. So, you know, at some point in 2015, 2016, where you were having the income splitting benefits, it changed over where there were more stringent requirements with respect to your children being part of the corporation and what have not, where you would not be receiving the tax savings. So there's always a caveat where you are trying to use a trust for tax saving purposes. You want to make sure you're up to date with the current tax laws. The other trust type is a testamentary trust. Now, this is created upon your death. It's usually created in a will, and it takes effect upon your death. And the trustee who's mentioned in your will, they hold legal title to your assets, and they are to be preserved and managed for the benefit of the others, as per, you know, the directions in your will. Now, oftentimes the trustee in a will is also a beneficiary. So like I gave the example with Bob, when Bob passes, his wife will be a trustee to handle his assets, but she is also a beneficiary where she's supposed to receive some of the assets. So that's one of the common things you'll see in a testamentary trust. Next slide, please, Ryan. And so with a living trust or an inter vivos trust, you can continue to add property to it over time. That often happens where people have businesses and they've utilized what's with an estate freeze. They've utilized a family trust, and so properties and businesses and shares are added over time. And of course, that's with the intention of having some form of a tax benefit over the years as the business grows or as the value of those assets grow. Now, trust assets, when it has been transferred into a trust, they do not form a part of the person's estate. So that's one of the key benefits, and they're not subject to probate. And so I'll get into it a little bit later, but there's probate fees or estate administration taxes that have to be paid where a person is deceased. And so where you've already transferred property into a trust, it doesn't pass through that estate probate process, so to speak. And so some of the uses for inter vivos trusts are typically to protect children that you may have from a previous marriage. And I'll do an example of that a little bit later on. There's also to ensure there's a source of income for minor children or disabled persons as well. As I mentioned earlier, there's a lower taxation of investment income, but there's always that caveat. You have to plan it accordingly and make sure you are meeting the CRA guidelines. And as I mentioned, you bypass probate. So the more assets that you have not, you know, outside of your will, the lower your estate administration tax. And some of the other ones that a lot of people don't consider with respect to an inter vivos trust is that it's the level of privacy. Where you have a corporation, the information for a corporation is available publicly. Someone can search or have a lawyer search who the directors of the corporations are, the registered address, and so on and so forth. When items or when property is put into a trust deed, now it's private. And so often where there are high net individuals that require privacy and they don't want their assets sort of available in the public sphere, that's where a inter vivos trust is also very beneficial. Next slide, please, Ryan. So trust planning for blended families. This is one of the issues that can commonly arise. It's where issues where with a new spouse and children from a former marriage, as I mentioned, often the biggest asset is either a family home or even a cottage investment property. And so you will have a surviving spouse and children that are from a former marriage that are unable to maintain the home together. And so typically what you will want to do is leave the property for the spouse to reside in, but upon her death, the children are to receive the home. And so one of the things at law that's required is that if the children are entitled to into the home after the death of the surviving spouse, they are supposed to be responsible for capital improvements. And what that means is things like changing the roof, foundation cracks and whatnot. Those are supposed to be handled by the beneficiaries, such as the children. And then, of course, the surviving spouse that is residing in the property, they retain the benefit to stay in the home, but they're responsible for the ongoing maintenance. So things like, yard, snow removal, and internal repairs with respect to the property, nothing structural, obviously. And so with blended families where there is a concern with the surviving spouse and the children, former children of a marriage not being able to get along, it may be prudent to appoint an independent third party. And this might be your Aunt Mary, for example. She's the trustee and as part of a discretionary family trust that maintains, the finances and the home as well, so that both the surviving spouse and the children, their interests are protected. And now there's always this caveat. There's always tax and non-tax considerations. As many of you already know, properties, they appreciate very, very quickly over time. And so, there's land transfer tax considerations when the property is transferred at a later date. There's also tax considerations with respect to property taxes that need to be handled while the surviving spouse is still residing in there. So you always want to get the full picture with respect to, okay, well, who is legally on title for the property, but also what are their obligations with respect to taxes, and then what are their obligations upon transferring the property, say, to the children later on, or disposing of it later on as well. Next slide, please, Ryan. And so some of the trust pitfalls, as I've mentioned, one of the main uses for a trust is what's called an estate freeze. And that's typically where you utilize a family trust with your small to medium-sized business, where the shares of the business are actually held by the family trust. And that allows some of the income, if you have considerable income, obviously, you're allowed to, pass some of that income through the trust, and allows you to reduce your tax liability. And now, as I've been mentioning, there is that pitfall of attribution, where if you haven't correctly set up the trust, the CRA will turn around and say, well, no, you're actually going to be liable for the tax. It's going to be added to your personal income as opposed to flowing through to, say, your children as beneficiaries or your spouse. And so you want to make sure that when you're complying with all the CRA regulations and the rules with respect to taxation, and that often it changes, very, very, very often. And so, as I've mentioned, it's a complex solution. The most common one is an estate freeze, but you're going to be utilizing a lawyer as well as your accountant to make sure that it's financially beneficial for you. You meet the taxation requirements, and it allows you to, pass on those savings. Next slide, please, Ryan. So this part is the estate administration. So a person has passed away, and typically either through the will, or if you don't have a will, you'll have someone that's referred to as the estate trustee. And again, it can be a corporation at times as well. And this is a person that's appointed to do the work of tidying up your affairs after you pass. Some of the responsibilities for the trustee include filing returns. So there is a tax return that's filed when a person is deceased, and you are expected to obtain a tax clearance certificate from the CRA. And on top of that, you have to locate and preserve the assets of the estate. And sometimes that can be quite time consuming as well. But also identifying the beneficiaries that are still alive and mentioned in the will. And if there is no will, then other beneficiaries that would be entitled to inherit. And then proceeding with distributing the assets in accordance with the will. And if there is no will, again, as Jason had mentioned earlier, you have rules of intestacy. And then, of course, there's the closing of the bank accounts and credit cards. Typically nowadays, financial institutions are very well prepared. So when someone is deceased, what they'll do is they'll open up what's called an estate account, and all the assets will be transferred there in terms of whatever's in the bank accounts, investments, those types of things. And it's there for whoever, either the personal representative or the estate trustee is, to handle on their behalf. They also have an obligation to pay off debts for the deceased, collecting insurance payouts if there are any that are left in the estate of the deceased, as opposed to directly to the beneficiary. So if it goes to a spouse and the children, then it'll be transferred upon death. And then, of course, the major one is transferring title to real property. And I'll get a little bit more into that in some of the next few slides. Next slide, please, Ryan. So a certificate of appointment of estate trustee, it's not always required. It may be required for certain financial institutions or other organizations that hold, say, investments. Typically, where you have appointed someone as a beneficiary through the financial institution or organization, you won't need to get a certificate of appointment. Others will have a very strict policy where it is required. So the first step is always finding out whether or not the certificate of appointment is required, or if the assets that are being held by these various institutions pass through a plan or through a beneficiary designation. And so that brings us to some of the ways that you can reduce the estate administration tax, because any property that forms part of the estate, to get the certificate of appointment of estate trustee, you have to first pay the probate tax. And so one of the ways is that you can dispose of the property during your lifetime. And so that means if you have children and you've decided that, look, my children are going to inherit this property anyway, you put them on title as joint tenants or tenants in common, depending on how you want to structure it. Typically with joint ownership, whether it's a bank account or real estate, the property transfers outside of the will. So suppose it's you and your spouse that are on the joint bank account, or it's you and your spouse that are on title for the property. Once you pass, it automatically transfers to the remaining joint tenant. And so it avoids the necessity of going to obtain a certificate of appointment and going through the court process. The other way that's often done is through plans. So where you have RRSPs, insurance plans, your RIFs, your TFSAs, they have a beneficiary designation. And so you're not often required to get a certificate of appointment of estate trustee. This simply, as you pass, the beneficiaries receive access to those plans as they've been designated. Next slide, please. So when you are required to apply for a certificate of appointment, and it may be that there was no will and there's real estate, or it's a specific financial institution where there wasn't a beneficiary designated and so it's required. The new rules that have come into place, if the assets are worth $50,000 or less, there is no estate administration tax or probate payable. But for every $1,000 that are greater than 50,000, you have to pay $15, or so essentially 1.5% for every 1.5% essentially for anything above $50,000. So what's excluded from probate for the purposes of probate is real property outside Ontario. As I mentioned previously, any jointly owned property or accounts, and life insurance proceeds that are paid directly to the beneficiaries, or benefits that are paid through a plan designation. And so just a simple example, if you've got the house, the car, and the sole bank account, the total assets are worth $950,000. You'll pay the estate administration tax on $900,000, which at 1.5% would be $13,500. So this payment would be required as you apply for that certificate of appointment. There are, of course, several rules and exemptions with respect to what are the assets that form part of the estate. So, for example, if you've got that $1 million home, but there's only a $200,000 mortgage, obviously that $200,000 liability is deducted. Next slide, please, Ryan. Oh, so I'll be passing it off to Barbara now, and she'll be talking about the intersection of estate and family law, as well as some real estate implications with respect to estates.
Thank you, Adele. All right. Thank you, everyone. I know it's been a lot of talking. We're going to be, I think, a few more minutes with me presenting, and then we'll get to Q&A. But I am here to chat about the intersection of estate and family law real estate and family law with regards to estate and wills. Ryan, next slide. So to start, I will be discussing common law spouses. So as you may or may not be aware, common law spouses do not have the same or equal rights to spouses who are legally married. This is apparent when you look to whether a common law spouse is able to divide property or to inherit at all at law. So the best way to remedy this is by the creation of the cohabitation agreement or a will, which would outline your common law spouse's rights to your estate or property upon your passing. Now, common law spouses who have both a cohabitation agreement and a will help to establish and affirm their intentions towards the common law spouse, which can be argued, by those who are beneficiaries in the event that there is no will, or the common law spouse is not mentioned in a will, or there is no cohabitation agreement. Having said all of this, though, common law spouses do still have first priority when it comes to electing to act as executor of the estate upon their common law spouse's passing. Ryan, next slide, please. Thank you. So now we can also talk about separated spouses. So as has been previously referenced, marriages void a pre-existing will, but divorce does not. So if you divorce a partner and do not change your will, your former spouse will have the option or right to elect for equalization of the property instead of taking their inheritance under the will following your passing. So as you can imagine, this can lead to great mishap and disappointment with a current partner or children. So you can combat this type of occurrence happening by executing a valid separation agreement or marriage contract, which some of you might know as a prenuptial agreement. So a valid separation agreement in this instance is typically one where both parties have received independent legal advice or representation and financial disclosure has been provided. A marriage contract can occur prior to marriage or during marriage. So it is in this document that you would establish what your rights are to one another following a breakdown in that marriage. Should you not have a separation agreement or marriage contract, simply executing a new will upon divorce will reestablish your, or divorce or separation, will reestablish your intentions for your property and estates. Ryan, if we go to the next slide, please. Now, I know this was alluded to previously with Adele's chat, but in second and third marriages and where you've had children from a first marriage, for instance, and maybe the new individual that you're married to has their own children or they don't, you may still be concerned with protecting your children's interest to your estate following your passing. So ways in which you can do that, which again, were very well put by Adele, are joint tenancy, wherein you would place your child or children on title with you to a family home. Joint ownership, where you would add a child onto your bank account or any other type of accounts. Beneficiary designations, which occur again with life insurance policies, RSP, TFSAs, etc. In these three instances, though, by adding anyone onto your accounts, title, or life insurance policy as a beneficiary, you can possibly forgo the asset being considered part of your estate on your passing. So it would protect your children's right to receive your property once you've passed, but this does come with risks. So any type of joint ownership or joint tenancy means you are giving a child equal access to assets prior to death, and it needs to be documented carefully and properly. So this type of access to your children, while it guarantees their interest in your property on passing, does expose you to your children's creditors and potentially not being able to utilize your own property or assets prior to passing without their consents. This can become further complicated and a less desirable path when you have multiple children, and on your passing, they could potentially argue the gifting of property or the sharing of bank accounts prior to death equal or constituting an unequal division of assets. The last two tools available to you are life estates and testamentary trusts, which I'm not going to go into such great detail on as I am more focused on real estate and family law. So Ivana or Adele, Jason, if you have anything you want to add for these two tools that might be applicable to protecting children in second or third marriages, please do share. But otherwise, I would say most common ones that I have seen are joint tenancy, joint ownership, and beneficiary designations. So Ryan, next slide, please. Thank you. So as I mentioned, by adding a child or children on title, this is specific to real estate, you will want to give consideration to how they should take title, because while one type of ownership will mean that survivorship occurs and the property will not go through your estate, the other means the property will still go through the estate. So as you can see here from the slide, we have joint tenancy and tenancy in common. The type of title that will help you avoid or help your kids avoid probate and estate issues is joint tenancy. So this means that you and your child or children own the property wholly and equally. And that means should any one of you pass away, it's the surviving joint tenants or joint owners will automatically be given the remainder of the property. So there's no need to even, there's no need to worry about that pathing, the death of that one individual going through an estate and then coming to you. It will automatically stay with the people currently on title. Now, if you are passing, typically what you'll see is a survivorship application, and that's something that you would come to a real estate lawyer with following death. So you would just need to bring a proof of death and proof of title, and you can get that done. But again, while this is beneficial, it does not incur probate taxes. One thing that you need to consider, and Adele did mention it, is that if you have a child on title with you as a means to avoid probate, and it is not their primary residence, you could be opening them up to capital gains, which would be taxed to them upon the sale of the property. So that's something to factor in, because sometimes probate taxes are not as cumbersome as capital gains. So the other form of ownership is tenancy in common. And now that is where, say you have 4 owners and they all own it equally, each would own 25% in the property. So they'd own a little chunk of the property that's separate to the others, but it would all equal together 100% of the property. What this means is that upon one person's passing, that 25% interest would not go to anyone else that's there. It would go to the estate and be distributed according to the will or the intestate rules, or whatever they have there. So this, if the value again of the estate is more than $50,000, will require court involvement to get an estate trustee to actually effect the transfer of that following the person's passing. And again, this does incur probate taxes. If the person as well that's receiving the property doesn't plan to live there, again, capital gains taxes is a possibility as well. All right.
Great. Thank you very much, Barb, for your input. We really appreciate your time as always. Okay, so I think we're moving on to the question and answer portion of our evening. So we're just jumping into that a little bit early. So I think we'll start with our attendees who have raised their hands. So we'll start with those first, and then we'll move on to our Q&A session, and then we'll move on to questions that have been emailed in ahead of time. So Marion, you've been added to our presentation. As a reminder to anybody who's speaking as a result of raising their hand inside the participant Zoom option, once you start speaking, you will be part of the presentation, which will be posted later on Facebook. So it will be available for everyone to see publicly. So just have a care when sharing some of your private or confidential information. This will be posted publicly afterwards. So Marion, when you're ready, you can unmute yourself and you can go ahead with your question. Marion, I believe you have to select to unmute yourself, as our moderator has allowed you to unmute yourself. You just have to allow yourself to speak as well. Okay, so Marion, if we don't have you unmute yourself in just another couple of seconds, we're going to have to move on to our next raised hand.
Maybe look to the bottom left of your screen. You'll see the mute button. It'll be on muted. If you select it, it'll go to unmute.
Okay, so we're going to be moving on to somebody else instead now. I believe we have a second person who raised their hand. There should be, Christina should be coming up in a second. Okay, Christina, so you're unmuted. You can go ahead with your question. Christina, you should be able to speak. Are you able to speak into your microphone? Okay, so Christina, we're not able to hear you right now. We'll give you another couple seconds to try to figure out how to speak into your microphone. And Marian, if you'd like to raise your hand later as well or add your question to the Q&A, we'd be still happy to answer your question. Okay, I do apologize, Christina, but we're having some trouble. If you haven't been able to turn on your mic, we're not able to hear you. So if you're able to figure out your mic issues afterwards, we'd be happy to take your raised hand question again. I'm going to move on to the Q&A questions. So I have our first Q&A question here. So it says, I'm going to receive a financial request from a deceased friend in the USA. Do I have to pay any taxes? I believe, Adil, do you know the answer to this, or should I answer this question?
You can take this one on. That's fine.
Okay. So in short, if there's ever any income brought in from a foreign country, then the de facto rule is yes, you do have to pay taxes. And this is especially true, and it's part of the reason that it's especially important that you do estate planning in advance. So there could be exemptions and there could be restrictions. Normally when there's really specific tax questions like this, we refer you out to some of our accountants. So we have some professional accountants that we work with to give you the specific answer, but the de facto rule is yes. So you will likely have to pay taxes. Okay. So I'm going to move on to the next question. So here, the next question we have in the Q&A session is an executor obliged by law to show a will to the deceased children? So Jason, are you prepared to answer this question, or would you like me to answer it?
Yeah, I believe that, you know, once the person has passed away, if the child is a beneficiary, then they have a right to see the will. If not, then the executor should be telling them everything that's going on anyway. But if you have anything to add, go ahead.
No, that's right. So if you're a beneficiary under the will, especially what's known as a residual or kind of catch-all beneficiary, then yes, normally you're allowed to see a will. However, if the child is not a beneficiary of the estate, a child doesn't have a right to see their parents' will. It's only a beneficiary. So the answer is your child can see your will if they're a beneficiary of the estate. Okay. So Adele, here's a question for you. It's an estate planning question. The question goes, what is the difference between setting up a holding company versus setting up a trust from an estate transfer perspective? So can you speak to that, Adil?
Yes, I can. So the holding company is often used in estate freezes. And what you will be using a holding company for is your assets that are going to grow over time. You want them to be transferred to the holding company to utilize an estate freeze. And what the benefit of is that suppose you have shares in a company, and you know when you start off they're worth only $1. But if you transfer those shares into the holding company, it can grow without the tax benefit or the tax repercussions after when you dispose of them. So a holding company is often used when people are trying to utilize an estate freeze. And that will depend on how your assets are expected to grow. And you'll definitely want to get tax advice with respect to what is that level of income that's coming in from this asset that I need to start thinking about putting it into a holding company as part of an estate freeze. And sometimes a holding company is also used for other practical purposes if you're holding real estate and you don't want your operational company utilizing it. But that's more of a business law question. With respect to the trust, as part of the estate freeze, you can also have a trust in order to manage that holdco. But the trust on its own can also be used for other types of purposes. For example, if you've got minor children or disabled children, you can have a trust that's created for them as beneficiaries, a family trust, or if you've got other purposes, you can have a trust that's independent of the holdco that's created where an asset is transferred directly. Usually that's not done these days because of the tax implications of leaving investment income into a trust. It's taxed at the highest marginal tax rate. So again, you need to get that proper tax advice. The lawyers can definitely set up the structure and do the corporate assignments or the resolutions. But depending on what your purpose is, what the cost benefit is, that's where you want to speak to a lawyer and a tax professional to say, okay, is it worth it for me yet? No, it's not. Okay, when do I come back? What's the growth that I'm looking for? Okay, so I hope that answers it with respect to that holdco and the trust. And sometimes they are used together, and oftentimes they are for the estate freeze. Okay.
Thank you very much, Adele. Okay. So our next question here is for Barbara. So it deals with a real estate issue. So Barbara, the question here says, are there any time restrictions for a joint tenancy? For example, a joint tenancy was formed a day prior to death. Would that be recognized as a legitimate estate transfer?
Good question. So what I would say there is, just to remind you, it's not called an estate transfer. So when you are adding someone on title, it's still called a transfer. So if you wanted to, as an adult, as a parent, add a child, you could certainly do that. And then say you do it one day and the next day you pass away, so long as there wasn't any issues with capacity and you had the ability to do this transfer. It wouldn't necessarily be seen as an estate transfer. It would just be seen as a transfer of title with very coincidental timing, I would suggest. But yes, no, if it's there is no timing or timing restriction. If you've gone through the documents and you've registered the documents and then they pass away the following day, it doesn't matter. You're still on title as a joint tenant. So title would come to you.
Okay, so there we have it. No time restrictions on joint tenancies as far as Barbara knows. Thank you, Barb. Okay, so the next question that we have here is from, is this. So it says here, my husband passed away and his will said all assets go to me, his wife. I now want to sell the house. Do I need to see a lawyer to have the house put only in my name, or does the will cover that? So
I can answer this. Yeah.
Go ahead, Barb.
Yeah. So because there is a will, it doesn't, by its nature, having said that, mean that title automatically goes to you. You still need to do a transmission application. So because it's given to you through the will, you would show the lawyer, the real estate lawyer, the will, proof of death. They would then take those documents and create a transmission application. And then following that, the name comes to your name, or the title would go to your name. You could then sell the property under your name. So that would typically be done the same day the transfer is done to whoever is purchasing the property. You do the transmission, then right after that, you do the transfer.
Great, thank you very much, Barb. Okay, so I have another question here. It's an estate planning question. Either Jason or Adil, I'd be happy to have you answer this. So it says here, how can we bind the children to allow their mother to live in the house and shares only be divided after the death of the surviving mother of the children? Can we make a trust?
So I can take this one, if that's okay.
Please go ahead.
Yeah, as Adil mentioned, yes, you can do this, and it's by way of making a testamentary trust where you give the surviving spouse a life interest in the estate, and only after the spouse passes away do the children inherit. So yeah, you're completely right. There is a way to do that.
Great, thank you very much, Jason. Okay, so I have our next question here. I think Jason can answer this question as well. So it says here, my son is under 5 and I would like him to inherit my house should the worst happen, God forbid. Can I say his mother must pay a small amount of rent to the estate to live in the house?
Maybe you'd like to just take that one.
Sure, no problem. So when you're planning for your estate, I'm gonna give general information on this question here. So when you're planning for your estate, you can really provide for pretty much anything you choose to have happen in the estate. So if, for example, if you'd like somebody to have to go to school before they inherit a bank account, that's something you can provide for in the will. With your circumstances, it's hard to say 100% what the best route would be because there's a lot of facts that we would have to ask after. So for example, is the mother also on title to the property? Are you two married? Are you two common law? Are you cohabitating in the house? There's a lot of questions that would have to be answered before we're able to give a specific answer. But general information wise, you can put whatever you like in your estate, and subject to other kind of conflicting rules or laws. So like I said, for example, if the mother is also on title to the house, you can put in your will that you'd like someone to pay rent if they want to live in the house. But in your case especially, I'd really recommend that you either book a consultation or speak to us. We are still offering free consultations as far as I know, so we can go over really the specific nuances of your circumstances. Okay, we have another question here for Barbara. So Barbara, we have a question here that says, my understanding is that a cohabitation agreement and a will is kind of the same thing. Are you able to kind of describe the difference between a will and a cohabitation agreement?
Sure,
just very briefly.
Yeah, so whereas a will deals with your assets following death, a cohabitation agreement isn't solely focused on death. It's focused on the breakdown of the relationship. So you could have the relationship break down, but then have years and years and years before you pass. So you need to account for that time and whether or not there's going to be any kind of support, if you have children, if you're going to be paying for children. So there's other factors that come into cohabitation agreement that wouldn't be addressed in a will.
Thank you very much, Barb. Okay. I have 2 more questions, I believe. So let's pull up the next one. Oh, we've got a lot more. All right, so we have a question here that I think either Adele or I can answer. So it says here, when would you have to pay capital gains tax on a cottage that is owned by 4 family members? Only when I sell it or when one of us passes away? So I think this is something we would normally refer, actually, I think this is normally something we'd refer out to an accountant, because I think that depends on whether or not it can be deemed a principal residence, how the 4 of you own the cottage, what kind of way it is held, when it's sold, the adjusted cost base. So this is another one of those kind of really specific nuanced questions that requires us to figure out a lot more facts before we can give a specific answer.
Yeah, Ivana, to add to that, so I do know a bit about capital gains on cottages when it comes to the payment of it in a sale. But you are right, it does depend how ownership is held. So if the 4 of you are joint tenants, it would be passing to you automatically, so there would be no capital gains upon that passing. But if you do pass away and your tenants in common, with any kind of property that is not your primary residence, whatever your portion is will be taxed with capital gains. So I know too with cottage properties, it's a concern because sometimes they can be in the family for generations, and you're dealing with an increase in value from the time you bought it. So that could be a very onerous amount. So that's where you really do want to look into whether or not ownership should be held as joint tenants or tenants in common. But typically, if it is joint tenants and then it moves into another group of people, it becomes payable upon the passing of the original joint tenants. That's a high level answer, just by the way. I would need much more information.
Ivana, I think you're just muted there.
Sorry, thanks, Adele. So Barb, we have 2 quick follow-up questions. So yep. The first one is, how do I know whether it's joint tenancy or tenancy in common?
Yes, so that is a good question. If you have your transfer documents or your real estate documents from when you bought the property, your lawyer should have given you a copy of the registered transfer. This would indicate whether or not you are tenants in common or joint tenants. Alternatively, if you really didn't have that information, you could absolutely go to a land registry office and purchase a parcel register, which would tell you how you own the property. These typically run about $40. And at the very top of it, it would say the name of the owners, and to the right of them, how they own it. So it'd say joint tenant, or it'd say tenant in common. And if it's tenant in common, it'd give you the percentages that is attributed to each owner.
Perfect. And then one more follow-up question. If it's okay with my parents, can we add my 2 sons on the ownership of the cottage? And if so, how can that be done?
Okay, so this sounds like grandparents and grandchildren. So if that is what they decide to do to keep it in the family, then certainly that can be done. What I would suggest you do is speak with a real estate lawyer like myself, and I can tell you how title could be held. Pardon me. And I can discuss how title would be held and how that would affect you, and how capital gains could possibly come into it, also how any kind of tax could come into it. But then as well, there are risks involved with having other individuals like children or grandchildren come on title, because like I've said previously, if you're joint tenants or tenants in common, regardless, you now have an asset that they can, their creditors, if they ever get into financial issues, can come after. As well with grandchildren, if they're young, by placing them on title, if they've never purchased property before, they are losing out on the first-time home buyers rebate, which is something that's available to first-time home buyers in Ontario. So there are a bunch of factors that need to be discussed to see if it's worthwhile for the grandchildren.
All right. Okay, thank you very much, Barb, for those answers. All right, so I'm gonna skip down the line to give Barb a bit of a reprieve and just go down to this question here, which I think is a question that Jason can answer. So Jason, we have a question here that says, can a lawyer witness the will and another lawyer is working in his office be the other witness? Does this affect the will? So it's a question about who can witness a will.
Yeah, so any adult that is named in the will can act as a witness, and this includes the lawyer drafting the will, as well as another lawyer or anyone in the office. Really, it doesn't have to be a lawyer that's acting as a witness. not only does it not affect the will, if anything, it probably makes things more convenient for you if you're having a lawyer draft your will. Because then you only have to go to one place and all your witnesses are there and you get the will and you have it all explained to you at the same time.
Okay. Perfect. Thank you very much, Jason. And actually, I have a second follow-up question, or not a follow-up, but a second question that I think Jason can answer as well. So, Jason, we have a question here that says, if you add a note to your will, which is not a codicil, saying that you would like certain sentimental items to go to specific people, is there any obligation on the executors to comply with this note?
Perhaps you'd like to add something afterwards, but I think that it's best to do this by way of a codicil, and that actually puts it as part of your will. I don't think just having a note that isn't specifically a codicil would have that effect. And so I think that doing so by way of a codicil or an updated will is best.
Okay, thank you very much, Jason. Very good. So I think that answers those questions. So I think these are all other questions about properties and mortgages. So I'm just trying to read, there's a long one here. Okay, I'm going to read this question out and we'll see who is best suited to answer this. So there's a question here that says, my principal residence still has my husband on title, which I haven't removed his name yet. I'm waiting to sell it. What about the rental property still has my deceased husband on the title? So I think the question is, the rental property still has my deceased husband on title. So is that going to be a concern for my ability to manage the rental property? So Barb, do you maybe want to answer this question?
Sure. So it also depends on if you are on title, and if you are on title and you're on title as a joint tenant, you would need to go to a real estate lawyer to have a survivorship application done. This is very straightforward. It can be done quite quickly. So that's what I would recommend if you're a joint tenant. If it was tenants in common, then you'll have to figure out what happened with the estate and why title wasn't changed to the beneficiary. So that would involve meeting or chatting with the estate trustee, or if you are the estate trustee, coming to a real estate lawyer to help effect that transfer.
Okay, great. Thank you very much, Barb.
Mm-hmm.
I have a question here that I think is for Adil. So Adil, the question here says, I have shares I inherited from my mother before she died 7 years ago. We never paid capital gains taxes on the shares or capital gains on them. Is this something I should look into paying now, or do my beneficiaries pay them after death?
So certainly you want to look into, well, first of all, I just make sure that shares have been transferred in your name. And so the corporation should typically be doing that. One of the things that you may have qualified for, and this is more so for an accountant, is whether you qualified for a Section 85 rollover, whereby you are not paying the capital gains on the shares. And then upon a disposition later on, then yes, tax is payable and the capital gains is attributed to you. So you're going to have to speak with an accountant. First of all, make sure that the shares are actually transferred in your name, but then going to an accountant and figuring out, did I qualify for the Section 85 rollover? In which case, no, I don't have to pay the capital gains at this point, but later on, or if there's a deemed disposition, for example.
Okay, thank you very much, Adil. So I have one more question for Barb, then one more question for Jason, then we'll move on to the emailed in questions. So Barb, the next question we have here is, my spouse and I have multiple properties that each have mortgages. In the event of the death of one of our spouse, our income level will probably not meet the amount to qualify for a mortgage. Will the banks typically force the estate to divest the properties to pay down the outstanding mortgages, or will it be possible for a surviving spouse to hang on to the properties and sell or divest at a preferred time?
So that's a very good question. And that is absolutely one that I would direct you towards a mortgage advisor for. So it is dependent on the banks, but if you are not defaulting on payments, I don't foresee there being an issue with the status quo. You will need to advise the bank of the passing of the individual on the mortgage. But if you are able to keep making the payments, you should typically be fine. But that's something that you would have to assess based off your income level and your assets.
Thank you very much, Barb. And Barb does have I understand, a bunch of professionals she can refer you to if you do engage her. So
if there's ever any real estate questions that require a bank involved or insurance providers or whatnot, I'm able to give referrals.
Perfect. All right. And then I have one more question for either Jason or Adil. So we have a question here that says, what is the difference between a probate and a non-probate will?
I think I could take this one. So rather than a probate versus non-probate will, I think what you want to be thinking of is assets that need to be probated and assets that don't need to. So as Adil said earlier, if your estate is worth $50,000 or less, then you don't need to pay probate on it. But also, for example, what Barb said, if you own a property as a joint tenant, that won't pass through your estate, so that wouldn't have to be probated. So it depends on the asset rather than the will as a whole.
Perfect. All right. Thank you very much, Jason. So if there are any more questions that come up during the presentation, please feel free to add them to the Q&A, but I'm going to move on to the emailed in questions now. So we're going to start at the top. So we've already assigned these. So Jason, we're going to start with a question for you. So we have a question here that says, I have one child that's passed away. He had no will, so his house went under probate. My problem is that his ex-common law partner has been living in the house. Does she have the right to continue living in the house? There's also 2 children who are still with the ex-common law partner. Do I have a right as a parent to any of my son's assets? So Jason, I understand you're prepared to answer this question.
Yeah. So like I mentioned when I was talking about intestacy, common law partners don't actually have the right to inherit under intestacy laws. Under intestacy laws, children have the right to inherit. So do parents, but if there are surviving children, they will inherit the entirety of the estate rather than the parents.
Great. Okay, thank you very much, Jason. All right, so I have a question now next for Adil. So Adil, the question here that we've had emailed in is, my biggest concern is that if I should predecease my husband, I want to ensure that my children will receive my share of the matrimonial home value. How do I plan for this?
So typically the best way to plan for this is to have a trust or testamentary trust clause in there where it handles that, but both of you would be required to have that clause. And this is probably one of the biggest concerns. The issue though is once you pass, nothing prevents your spouse from changing their will. So you have to make sure that you both have that trust clause that's there right at the beginning, that if one of you passes, you hold the life interest and vice versa. The other way that may be more beneficial is, as Barb has mentioned and I've mentioned as well, is to put them on title prior to your passing. And so have them on there either as tenants in common with a specific percentage that you want to attribute, or as joint tenants. Of course, if your spouse is already on title, you know their consent will also be required. Actually, their consent will be required irrespective if they're your spouse. So there are ways to have it done through the testamentary trust in your will, but it might be more prudent to do it through using tenancy in common, prior to passing away. And of course, I like to always add that caveat. There are land transfer tax implications if you don't do it, and there are capital gains implications if you transfer it and the property has significant value. So there's always implications with land transfer tax, capital gains. There are also exemptions. So you always want to speak to a real estate lawyer or a lawyer before you make that decision as to how to plan for the estate. Okay.
All right, thank you very much, Adil. So that answers that question. Moving on to the next question. So this is a question for Jason. So Jason, there's a question here that says, I have a will and 2 powers of attorneys that I made online. How much would the cost be to get them notarized? Is this kind of will valid?
Yeah, so wills made online and through formats like that are valid, provided that all the formal validity requirements needed to have a valid will are followed. So like I mentioned, for example, it needs to be witnessed by 2 adults that aren't named in the will. So that would be one of them. And provided all of them are, provided that all the validity requirements are there and in place, then the will would be valid for sure. Something else I mentioned is that wills don't need to be notarized. So as long as everything is correct as far as formal validity, you're good. There are a lot of formal validity requirements. So if you do want us to look over that, we can.
Okay. Thank you very much, Jason. And actually, Jason's answering back-to-back questions now, so we have another set of questions here for Jason. So Jason, I am the executor and power of attorney for my elderly mother. She's currently holding my sister's mortgage along with my sister's credit card debt. My mother's current will is for the funds to be divided equally between my older sister and herself. I'm concerned that the debts, the mortgage and the credit card, will impact on her estate, and I have specific questions. So my first question is, what would I do with the mortgage my mom's holding? What would happen with the credit card debt? And I'm worried that my mom's estate will be bankrupt. Can you assist? Thank you.
Yeah, so I'll just go over these in order. So when you are dealing with the assets of an estate, you have to pay out the expenses first, and they are paid out of the estate. So as far as the mortgages go or any debts, those have to be paid out before anyone inherits. The same goes with the credit card debt, same thing as the mortgage. And if the estate is bankrupt, then the only thing you have to pay are personal income taxes.
Okay, great. And as we've said along the presentation, I'm just going to reiterate now. When we look at specific fact situations, normally there's a lot of follow-up questions that need to be made to give specific advice about your estate or your estate plan or the consequences of decisions that have been made. So if the person who's emailed in, if you're watching, if you'd like to, we're offering free consultations. If you'd like to book a consultation just so that we can get a few more details about what the specific circumstances are, we'd be well placed to give you advice in that case. But right now, with the information that Jason's given, that's as much as we can really do right now. Okay, and then last question in a row for Jason. So Jason, just to confirm, what does probate mean? Do all wills need to be probated, and is there a way to avoid having your will probated?
Sorry, Jason, you're just muted there.
Yeah, I just realized, thank you. So like we talked about, probate or estate administration tax, it's a deemed disposition on death. And like a question before asked, it's not so much do all wills need to be probated, it's about the assets in the wills. And so, for example, assets, some wills provide for, they just mention real property that will pass by way of joint tenancy, or they mention intended designated beneficiaries on tax-free savings accounts. So those assets would pass outside of the estate. And likewise, that would be the way to avoid having those assets probated. You know, there are a bunch of ways that we can help you with if you want to book a consultation with us. But as far as the facts we're given right now, that's all I can say.
Okay, thank you very much, Jason, for that. And just, I think there's a bit of a nuanced answer that needs to be given to this next question. So do tax-free savings accounts, TFSAs, pass tax-free to your adult children who I identified in your will? So do you want to unpack that question?
Sure. Just making sure I'm not on mute.
You're all good.
Okay. So it depends what you mean as far as were the beneficiaries designated or whether they were identified in your will. So if you're saying that in the will you're designating them there, it would be brought into probate. However, if you have designated them as beneficiaries through your TFSA and through your bank, then it would pass outside of probate. So it sort of depends on which meaning you're giving to that question.
Okay, thank you very much, Jason. All right, so I have a question now coming up for Barb. So I think we've gone over this one briefly already, but just looking for a high-level answer to confirm it. So is a principal residence taxable when you die? If it passes to your adult children, do they have to pay capital gains taxes when it's sold?
Okay, so good question. If you've lived in a principal residence and you've passed away and it's going through the estate, that's considered a transfer from the deceased. So because it was your principal residence, the estate would be exempt from paying capital gains on that property. If it was going through your children through the estate, again, the estate would not be paying capital gains. Your children, on the other hand, if they don't live there and it's not their principal residence, they will be paying capital gains. Now, if one of them doesn't live there right away, but then moves in a year or two later and decides to reside in it for the period of time, and they end up selling it years down the road, they would fill in a separate tax form upon the sale of the property, which would account for the fact that it was their principal residence for so many years, and then also account for the fact that it wasn't their principal residence. So there'd be principal or there'd be capital gains tax on a portion of the time they own that property. But yes, it's not taxable on an estate transfer if the deceased lived there primarily.
Okay, thank you very much, Barb. All right, so now we have a question for Adil. So Adil, there's a question here that says, I'd like to plan my estate to comply with religious laws for inheritance, but I face two issues. So I face the issue that in the case of joint tenancy, it automatically goes to the spouse 100%, which is not what I hope for. And the other issue is with family law, if there's an election for equalization, then 50% of the estate goes to my spouse, which is not consistent with my religious laws. How can we draft a will in a way that may not affect the local laws, but at the same not violate the local laws, but at the same time be compliant with the religious laws? I'd really appreciate your assistance on this.
Okay, so with respect to the religious laws, it can get a little bit tricky. You will have it sort of specified in your will as a testamentary trust. The other way that you've also already mentioned is with respect to with joint tenancy, you can have it switched over to tenancy in common. So if there is a specific religious requirement with respect to what your spouse and your children are supposed to receive, you can have them put on title via tenancy in common with respect to what they're supposed to receive. However, that will still be subject to family law considerations, as Barbara had mentioned. So, for example, if you provided your spouse less than what she may receive under family law through equalization, they always have that opportunity to elect under family law rules to have the division of the property through equalization, and so that caveat will always be there. And so really realistically, the best way is, and I've done a few of these consults and I've done a few of these wills, is typically you have you and your spouse come in, and we find the best way to sort of draft the will where your wishes are protected. But realistically, where you are trying to comply with both religious requirements and you're trying to avoid the family law requirements, it's not going to be possible. It's very difficult. Even if you are able to do it, they are always able to make a dependence claim or a support claim from your estate if that is the case. So this one, I believe, is very specific, and you do want to consult with a lawyer. There are ways to do it. I know I have done it. You codify what's required either in the will, or you put tenancy in common with respect to your property, and so then that way it takes care of all the religious requirements. But I hope that gives you a little bit of clarity in which way to proceed with something that specific.
All right, thank you very much, Adil. All right, Jason, we've got a series of short questions here for you. So I'll start by reading them out. So it says, first one, after making a will, do I need to give a copy to everyone mentioned in it?
No, you don't. Any of the beneficiaries are entitled to see it if they would like, but you don't have to go out giving a copy to everyone. They will more likely than not see it when the person who made the will has passed away. But as far as when you make the will, no, you definitely don't have to give it to everyone mentioned there.
Great. The next question is very simple, but a very often asked question, which is, how will my grandchildren know what they're inheriting?
They can ask to see the will, and then if they're beneficiaries and they know that they're going to inherit something, they can see exactly what is going to happen.
Mm-hmm. You can also tell them what they're inheriting. You are allowed to show them the will while you're still alive.
Yeah, that too.
Yeah, so just so everyone knows, wills are technically confidential property, so they are your confidential information. You don't have to share them with anyone if you don't want to, but there's nothing that prevents you from sharing it with anybody while you're still alive, or telling them what they're going to get, or sharing copies. Okay, next question for Jason. So will a lawyer contact my grandchildren or beneficiaries after I pass away?
So there's no automatic process by which a lawyer gets involved in an estate. It really depends if the executor has hired a lawyer and has instructed them to do so.
Okay, so that leads to the next question. Who contacts the lawyer when I pass away?
It would be the executor, the named executor in the will, or if there are more than one of the named executors.
Thank you very much. And then we have two a little bit more specific questions that follow up. So it says, my mother passed away and no one has shared any information with me, not even the name of the lawyer for the estate. Can I be excluded from my inheritance by the executor claiming that they cannot locate me?
Right. So if you know your beneficiary, like we said, you can ask to see the will. But also, if you're afraid of being excluded because an executor cannot locate you, quote unquote, locate you, there are ways that you can make your presence known and make sure that you're included from then on. And those ways, just to name a couple of them, you can file a notice of objection in court, or you can bring in motion to compel a passing of accounts in court. And both of those will have you included from then on.
Okay.
I could just add to that as well. If you're concerned about the information not being shared, typically what you want to start off with is the location where the deceased was residing last. So for example, if they're in Toronto, you can actually go to the Toronto courthouse and find out if there has been an application made in the deceased's name. So each jurisdiction where people can reside, that's where you can contact the courthouse and see if a lawyer has made a certificate of appointment. And typically that is your first starting point if you are concerned about there's a lawyer involved and there were assets and they're being distributed. Sometimes there are assets that do not need to be probated or do not pass through the will. And so if, for example, if there's insurance plans and whatnot, and you thought you were a beneficiary on one of the plans, that is obviously a little bit harder to do because those pass outside the will, and there won't be a certificate of appointment. So typically your first point or starting point is that local courthouse in the jurisdiction where the deceased resided. And then maybe a little bit more checking up with the financial institutions if you have the deceased's name, their birth date, and that type of information. But again, they'll only release it to either a personal representative that's been designated or a lawyer that is in the process of applying for a certificate of appointment, or a copy of the will that says, yes, this person is their trustee or representative. Okay.
Okay, thank you very much, Adil. Okay, so we've got a bunch of questions again for Jason. So these ones are probably advice-based, but at least Jason can give some information on them. So Jason, our first question here is, if my wife who was on title dies without a will, what will happen to our house?
So it depends if you are married or if you are common law spouses. So if you're married, then like we mentioned before, the surviving spouse and the children are entitled through the laws of intestacy. If you are a common law spouse, then you may have a claim under the Family Law Act, which is subject to something you should be consulting a lawyer for. But as far as the wife's share would go, it would be equally inherited by the children as per the intestacy rules.
Okay, thank you very much. So we have another question here for you, Jason. So Jason, our next question is, if she names me in her will, same question, what will happen to our house?
If she names you in the will, then it goes according to what's in the will. So if you and the children, if a spouse and a children are named in a will, then you would inherit as per the terms of the will.
Perfect. Okay. Next question is, if she names her children as her heirs in the will I still be permitted to live in the house until I die?
So like we had mentioned before, this is a situation where the testator can give someone a life interest in the estate and through a testamentary trust, and have the remainder after the spouse passes away go to the children. So there is a way to do it, yes, and that's generally the way that we think that you would.
Okay, perfect. And then lastly, it says, in all of the above scenarios, do I have to go through the probate process?
So if the property is not owned jointly through joint tenancy with a right of survivorship, then yeah, the property would have to go through probate.
Okay, great answer, thank you. Okay, and then we have a question here about foreign beneficiaries or foreign assets. So if one of the listed beneficiaries or another substantial assets in the United States, do the assets of the estate or the beneficiary still need to go through the probate process?
So if you are, or if one is named as a designated beneficiary on an RRSP, on a RIF, on a TFSA, then those assets will pass outside of the estate and won't be subject to probate.
Okay, thank you very much, Jason. So I'm going to just jump down to some of my questions to give Jason a bit of a break. You've been a champion answering all these questions. So I have some questions here, and they're my questions. So they say, the first question here is, what is the difference between personal care, property, probate, and non-probate will? So we've answered the question, the difference between a probate and a non-probate will. I did cover the difference between a personal care and property, but I just want to confirm that there are two kinds of powers of attorney in Ontario. One for personal care, which allows somebody to make healthcare decisions on your behalf, and one for property management, which allows somebody to make financial property asset type decisions on your behalf. So that's the difference between those two. The second question is, what is the difference between a trustee and an attorney? So an attorney is somebody who typically makes decisions kind of as a substitute decision maker on your behalf. So they step into the role of decision maker for you. Whereas a trustee is somebody who acts in your best interests and manages assets that are in a trust for the benefit of the beneficiaries. So really the difference is one person is acting in your place, whereas another person is acting for your benefit. So, and the next question is there a difference with the person who is named trustee and attorney on each of the will and what that means? So just to go over some of the language that we use. So a trustee is somebody who manages a trust, but confusingly in Ontario, we sometimes use the term estate trustee to refer to an executor or the person who manages your estate affairs. So while a trustee is supposed to be somebody who manages assets on behalf of beneficiaries, it can also sometimes mean the trustee of the estate. Whereas an attorney is, like I said, someone who steps into the role of decision maker on your behalf. And sometimes in a will, you'll also see the term executor, executrix. This is another term for an estate trustee. And sometimes you'll also see the terms testator and testatrix. These are the people who draft the will. So if you sign a will and you are male presenting, then you are a testator. If you're female presenting, then you're a testatrix. And we only have the two gender terms right now.
Ivana, if I could just add as well for the attorney part. Typically, when you're an attorney, the assets or property, they're still in the name of that person. So suppose you have a grandmother that suffers from dementia, acting as her attorney, the property would still be in your grandmother's name. Whereas a trustee, they are required to put the property or transfer title either into their name or act for the people or the beneficiaries and be transferring it to them. So that's a little bit of a nuanced difference there with respect to attorneys and trustees as well.
Thanks, Adil. Okay. And then I have a question, actually, Adil, that you might be able to answer as well. So the question here, Adil, is how can I do a will that will protect my future children if their father has done a different will?
Ooh, so that's one of the trickier circumstances. In those circumstances, it really depends who predeceases the other person. And you can have separate wills. Normally what you have is mirror wills where they're both similar. But if you do have separate wills, and we've seen that done, typically you will have separate lawyers that do draft it. But of course, you're always then going to be subject to either claims under family law, so whether it's a support claim or an election, or other claims with respect to creditors and whatnot. So what then it'll come down to is who predeceases first and how many assets or the type of assets that are left in the estate after it's been administered by the estate trustee. Typically that is a difficult situation. And so you want to speak with a lawyer and you have to sort of get an idea of what your spouse is trying to do in their will, even though you may not have access to it, and what you're trying to do and protect. And it'll also depend on how you're holding the assets, whether you and your spouse are holding them as joint tenants, which means it'll pass outside the will and it doesn't matter. Or if you are holding it as tenants in common, whether you have them designated under beneficiary plans or RSP plans or any other insurance plans as well. So for that, you certainly need legal advice. Typically when you have separation or you're worried about a former spouse or a spouse, impacting your children, you want to speak with a lawyer and get all the facts in, and they can advise you as to whether it needs to be put in a trust or how you can structure your will to best protect your assets. Okay.
All right, thanks, Adele. Okay, so Jason, we're ready to have you come back and answer some more questions. So Jason, I have the next question here says, what is the difference between a successor and a beneficiary?
So just like Ivana said, when there was confusion with trustee and estate trustee, I think the confusion here lies on the context of how you're talking about them. So for example, a beneficiary could be a beneficiary of a trust, or you could be a beneficiary of assets in a will, or you could be a designated beneficiary in something like a TFSA or an RRSP or a RIF. So really it depends on the context that you'd have those different meanings, and that's sort of what it leads on.
Okay, thank you, Jason. We also have, what is the rules if one dies first? It looks like banks have different definitions. So do you want to speak to the different ways that successors and beneficiaries kind of get appointed? Jason, you're muted again.
Sorry, can you repeat the question for me?
Sure. The question is, what are the rules if one of them dies first? It looks like banks have different definitions. So I think the question is, what happens if a successor or beneficiary passes away?
If a successor or beneficiary passes away and predeceases the person that was intended to make them the beneficiary, and it sort of cancels out that designated beneficiary, I believe. You may choose, if you have more to add, then please feel free.
Yeah, so with beneficiaries who pass away, it depends on first the way that the will may be drafted. So you can actually specifically account for what will happen if a beneficiary passes away. And then if the will doesn't provide for it, then the table of consanguinity that Jason put out earlier, that's what will determine who will take something if a beneficiary has passed away, if there's no will. With successors, especially for things like estate trustees or successor attorneys, that again, we start by looking at either a power of attorney document or the will document to say who's a successor trustee, who's a successor attorney. And if that doesn't exist, that's where things can get really complicated and unfortunately really expensive. And that's where people can slip through the cracks. So that's where, for example, maybe a beneficiary will get lost, an elderly relative won't be taken care of. And that's the crux of the importance of near end of life planning. So to make sure that you have somebody to take care of you and make sure that there's a backup to take care of you in case anything happens as well.
If I could just add, I think one of the items also that they had was that it looks like each bank has different definitions. And that's correct. So a bank may be defining a successor as someone that, so for example, if it's an investment account, the successor is someone that can have access to the investment account and start making trades. So you do have to make sure you understand how the bank is implementing their definition and what conditions and restrictions they may have placed. And you may need the assistance of a lawyer to clarify what these definitions are and what your rights are or what the beneficiary or successor's rights are. So certainly that's a valid question. And yes, banks will define each role differently. And so you'll just want to make sure, are you someone that's accessing or handling these investment funds or these accounts, or are you someone that's supposed to, just receive them and then they'll have it transferred to your separate account. For example, if you were at CIBC and they'll put it into your CIBC personal account rather than you continue accessing the estate account. So yes, you will need to speak with the bank and perhaps a lawyer to clarify those definitions, okay?
Okay, thank you very much, Adil, for the addition. All right, Jason, we've got 2 more questions for you and then another one for Adil. So Jason, we have here a question that says, what are the difficulties if a will specifies people from another country as either a beneficiary or a trustee?
So the biggest issue, and probably one of the only issues you may face, is locating them. If they're in a different country, like we had talked about, it's up to the estate trustee to locate different beneficiaries. Or if it's in the case of the estate trustee that is in a foreign country, having them learn that they are the estate trustee and they were named. If that's the case, it might be best to keep your will either in a safety deposit box or with a lawyer or someone that can contact whoever the estate trustee might be, or to simply tell them you're going to be the estate trustee of my will.
Yep, and then
go ahead, just a point to add with respect to estate administration, where you have a foreign appointed estate trustee. Typically, there is actually a bond required to be paid where there is a foreign estate trustee. And so that can be, I believe it's 10% of the value of the estate. So on top of the estate probate fee, you're required to post a bond where there is a foreign estate trustee appointed. So what you want to do, specifically have a clause in your will that specifies, I do not want a bond to be put forward by any foreign executors of my estate. Typically, a clause like that goes in. Otherwise, the court will not grant you a certificate of appointment, and it can really slow things down. Also, sometimes it's, and I've dealt with this scenario as well, sometimes you'll have people that have been appointed, but they are overseas. And in terms of estate administration, they may need to renounce and consent to a separate family member being appointed. Again, that can also be done when you are applying for a probate and the certificate of appointment, where the named estate trustee is foreign, and they'll say, look, I'll renounce, and my sibling who is in the country, they're better able to handle it, I consent to their appointment. So that's also a consideration that you have to realize, is that there might be practical issues when you are trying to administer the estate after a person has passed away.
Okay. Thank you very much, Adil and Jason, for both of your insight here. All right, one more question for Jason, then back to Adil. So Jason, we have a question here that says, my question is about my parents' home. Is it wise to go on joint title with right of survivorship to simplify the sale and reduce estate probate taxes? They have a will and they have executors named and the beneficiaries as well. Just wondering about estate planning. Thank you for your help.
So what is wise is incredibly subjective, right? So financially, you might consider it wise to transfer the title to, jointly by right of survivorship, so it passes outside of probate. But in the question, I'm hearing that there are 4 beneficiaries, all are the children. So practically, there may be issues because practically, if the testator were to pass away, the property would then go solely entitled to whoever the joint tenant or joint tenants are. So with 4 beneficiaries, all siblings, practically speaking, there may be infighting because of that, and that is, cottage properties, like we've talked about, are pretty contested, and this is one of the reasons why.
Okay, thank you very much, Jason. Okay, and as Jason said, as a reminder, it's easy for us to give it information, but if you'd like specific advice, we'd be happy to book a call with you. Okay, so now we have a question for Adil. So Adil says here, if I want to buy a house and include my parents' name in the ownership, are there complications after their death? Like their shares, will they be taken by the government or by my siblings? What can I do to avoid these complications?
Okay, that's a very good question. Typically, what you want to make sure that is, if you are purchasing a house, and Barb, feel free to jump in as well, because I know this is a real property question. But typically, if you are purchasing the property with your parents and you want to exclude all others from making claims, what you'll want to do is have it registered as joint tenants, which is basically last man standing. So if there's 3 of you, say one of your parents passes away, it's going to be the remaining 2 parties left. So it might be one of your parents and yourself, and then another parent passes away, then it's left with you. And that's probably the best way to avoid any claims. Having said that, I mean, if they want, they can always raise issues with respect to that they were promised, or they've contributed monies, or any other issues in terms of how the property was first acquired. But joint tenancy will be your best bet. You want to make sure it's not tenancy in common, because then it does fall to their estate, and so it is subject to claims of inheritance or claims under the Family Law Act as well. And also, if it is your parents' property as well, there also may be claims with respect to spousal support or dependence relief as well, if your parents are married, obviously. So it'll still be subject to that as well. But in terms of claims from your siblings and other parties, the best way to protect would be joint tenancy. And I think, Barb, you can add to it if there's other nuances that would assist.
I think you've identified it pretty aptly. Good job.
Good work, Adil. Got the seal of the Barb approval. All right. So next question for Jason again, and then I'll have a quick answer about pensions. So Jason, the question here is, I have a adult child who is not locatable easily. How do I set up a will to include her so she is on an allowance? Can this be done through an independent service?
Like we've mentioned before, the way one can do this is through a testamentary trust. And so in the will, you can say, I give this to blank in trust for blank. And then basically it will have, it'll be in the trustee's care to then pay to the beneficiary in accordance with the terms of your will. You can also make it so that the trustee has the discretion for when and how they pay the money or in what amounts to the child. As far as being done through an independent service, you can name anyone as trustee if they agree. And so if you find an independent service that is willing to do it, then of course it could be done through that.
Sure. And if I could add, I've done a bit of estate planning on this front as well. So one specific thing that I've done in the past is I've contacted the beneficiary, especially if they're difficult to locate or transient or just unresponsive. And what we did was we set up a specific bank account and then provided debit card access to that bank account, and then a specified allowance went into that bank account on a monthly basis. So in this way, they had access to funds on a monthly basis that they could spend as they saw fit. But the, so to speak, capital of the estate was still held in trust by the trustee. And independent services, trust companies do exist. They're normally fee-based, so you have to pay them a certain percentage or a certain fee every single year, month, whatever their fee schedule might provide. So normally when you set up some kind of trust in this way, we recommend that you either appoint a close personal friend, a family member, a sibling if possible, somebody that you know will take care of them without incurring these fees. But there are for sure independent services, including ourselves. We've acted as trustees for these kinds of things. So we professionals do offer these kinds of independent services. So that would be a way to set up to take care of those kinds of beneficiaries. Okay, and then the part two of this question is there a way for my child's son to be a beneficiary of her inheritance without her making a will? I'm sure she will not make a will as she is not capable of managing her affairs this way. So I want to make sure that my grandson is taken care of as well. So Jason, you can answer that question as well.
Right, so it depends whose estate you're talking about. So if you are talking about the child's inheritance for your estate, then your estate, in your will, you can deal with contingencies should the child predecease you and you wish for the grandchild to inherit. If you mean the child's will, then in that case, the child would need to be deemed capable and have a will. As far as what happens if they cannot, as far as I know, the intestacy provisions would take over. If there's anything to add.
So actually, I do have a technique that I've used successfully once. And so what it did was we said that you could earn, you would give the income of the estate to the daughter, but the capital would go to the grandchild after the daughter passed away. So we've done it in this way. It's kind of a long-term trust, and it definitely involves a lot of careful tax planning, careful estate planning. So there's definitely a lot more nuance required with that kind of planning, but that is an option that's available too. And that also depends on your fee tolerance. So those kinds of planning techniques can be quite expensive. So I assume that Jason was talking about something that was a little less fee intensive. Okay, so moving on to, we only have about 10 minutes left in the presentation, just shy of that. We're at 8:22 p.m. right now, so we have a couple more questions to get through. So we were sent a fairly long and detailed question about hoop pensions and other kinds of pensions and survivors' benefits for pensions. So I'll just give a high-level answer with that. So generally with pensions, if there's the ability to designate a beneficiary of the pension, the beneficiary is the one who receives the survivor's pension or the benefit or whatever the case may be. And it's hard to kind of intervene into the beneficiary designation and have somebody else take the survivor's benefit or other benefit. So you can have a benefit deferred to somebody else if the beneficiary effectively agrees to pass it on, but the chain still has to go through the beneficiary to start. And there sometimes might be exceptions or claims that can kind of creatively be made, but that's sort of the high level answer. And then the second answer is CPP survivors benefits. So as far as I understood, CPP survivors benefits go to the estate and anybody can apply for them. So you don't have to be a specific person to apply for them. And Adil, do you know otherwise, or?
No, I think that's spot on with respect to CPP.
Okay. All right. And so I really appreciate the time that this person took to write all the facts of their circumstances down. If you'd like to book a free telephone call with us later on, we'll have the answers, we'll have the facts in here, and we'd be happy to go into more specifics about how you can plan for this. Okay, so I have one last question that I was going to direct to Barb, which it deals with the split of a marriage and a long-term common law relationship. So the question is fairly complicated. So it says, I live in a house with an ex-spouse, where the ex-spouse is on title, and my common law partner and I are the ones who live there. But my common law partner and I have done significant renovations on the property, and my common law partner and I are worried that my ex-spouse, who is still on title, is going to benefit from the renovations. So Barb, when we talked about this, I understood that you said that was a pretty factually specific answer.
Yes, I need to know how you're on title. I also need to know if you are able to reach your ex. And when it comes to the improvements that you've made to the property, that would be a matter of finding, the first two items would need to be known, and then it would be a matter of potentially negotiating with the spouse as to the point of separation. What was the value of the home at that time? So maybe then they'd be interested in that sort of thing. But again, that's very fact specific. I would highly recommend you book a consultation. Yeah, so the circumstances outlined there, that's pretty classically where you need the intervention of both a family and a real estate lawyer, as Barb is, to ensure that everything is planned for properly. So outside of the bias of her being my coworker, Barb really is a very capable lawyer. Thank you.
So Barb, I have one more question for you. So it says here, my husband has passed away and I want to sell the house, but I can't find the deed. Do I need one to sell it, or where do I get one?
Yes. So when it comes to the deed, if you are on title, or if you're not sure if you're on title, you can, again, always go to the land registry office. Alternatively, you can contact us here at KPA. I am able to pull a parcel register for the property, and I can tell you how title is held. In any situation, if you were to do a transfer of the property without a title or without a deed or a transfer document, your lawyer in the process would automatically pull title to the actual, it's called a parcel register, which is why I refer to it that way, but they would pull title to the property to confirm that you are in fact the owner, and that is how you own it, and to see if there are any encumbrances on the property. So for instance, a mortgage or a lien or notice of security interest that would need to be dealt with prior to the sale. But yes, you would need one, but your lawyer can get it for you.
All right. Thank you, Barb. And then we have one more question, and then we're done with the questions for the evening. So our last question here, I'll give to Jason. So Jason, the question here says, if my husband and I both die at the same time, we have named his children as the beneficiaries of, I assume, both our estates. And it says here, what are the tax implications?
So according to the law, actually, if two people die at the same time, the law says that they have basically predeceased each other, like a moment before death. And so you'd go to each of the wills to see what would happen, and then the tax implications such as probate would happen as normal.
Okay, thank you very much, Jason. All right, so that concludes our question and answer session. So as we said at the beginning of the session, our presentation, which includes the slides, will be posted on our social media afterwards. I think Ryan will need a little bit of time to do that, so you might not see it right away, maybe tomorrow, maybe in a couple of days, depending on any kind of editing or uploading requirements. As we said, the slides will be included in the presentation as well. It's not our practice to circulate the slides, but they will be available on the Facebook recording. If you have any other further questions, you can feel free to call us. So we have our contact information. I believe you should have received it when you signed up for the webinar. If not, you can always email info@KPA Lawyers to set up a time to speak with one of us. We're offering free consultations right now. It's been a pleasure to speak to everyone this evening. We've been really pleased with all the questions that we got. If you have anything else you'd like to ask us, like we said, give us a call. Thank you very much for your time, everyone.
Thank you.
Bye, everyone.
Thank you.